Counsel, the judges of the United States Court of Appeals for the Fourth Circuit.
Mr. Ritchie, ready?
Good morning.
Morning.
May it please the court. My name is Ronald D. Ritchie, and I am especially happy to be here today with a voice, because I didn't have a voice yesterday. But, I'm counsel for Mario Alexander Sierra Rivera, the petitioner. The first issue I would like to address is relating to PSG, whether it's cognizable or not. We believe it is. The BIA, the board, just focused on two elements of the PSG, whether it's particular, whether it's socially distinct. The board claimed, we believe erroneously, that the PSG that was posited was permissibly overbroad, and relying upon the judge, the immigration judge, had said it was overbroad because it attempted to define by virtue of the fear that that the petitioner has because of police failure to take action against a private actor, which we know is not standard. We believe his PSG is particular. It has well-defined boundaries.
Let me ask you, counsel, that since the briefing in this case, our court has decided a case called Morales versus Garland, and the particular social group in that case, Salvadorian women who are witnesses to gang criminal activity and targeted because they filed a police report, seems to be very similar to the one you've suggested here, and that was found not to be sufficient. How is yours any different from that, or for that matter, the one in our prior case, Salela?
We believe it is distinguishable. First, of course, we're talking about Honduran males, different than El Salvadoran women. And in this case, reported the drug cartel activity, and then the police failed to take action. So there is that distinguishing features. And this, we believe, it provides clear benchmarks for the boundaries. It's clear in this case who's in the PSG and who is not. And so we believe that this case is, each case has to be looked at case-by-case analysis, of course, and we believe that this case is distinguishable. It has, as I mentioned, several self-limiting features, and it's clear who's in and who's not. We're talking about male gender, someone who's of the male gender, someone who's a Honduran Honduran nationality, someone who's reported drug cartel activity to the police. So it is different than those previous cases. This definition...
Well, in Morales, it was Salvadorian women, and they were targeted because they filed the police report. That seems very similar to what you proposed here.
It is, I concede it is somewhat similar, but I believe that there is enough to distinguish it.
So, and what is the distinction again, just so we're clear?
Well, one, we're talking about Honduran males, okay?
As opposed to Honduran females? I don't...
As opposed to El Salvadoran females, yes, Your Honor.
Okay, so, all right, what else?
We're also talking about someone who's reported drug cartel activity to the police, and then the police failed to take action. In the Morales case, other cases, you didn't have that component, that self-limiting feature of the police failing to take action.
Well, in the Morales case, these were women who actually filed a police report. Your description of reporting to the police seems even vaguer than that.
Well, in this case, the petitioner did attempt to file a report. He went to the police station, and the police refused to make a police report. In fact, they told him, join the cartel or leave. So it's different in that regard. We believe that there's, it's not ambiguous what the defined boundaries are of this PSG. He was a member of it. The immigration judge relied upon the matter of AB, which has been vacated by the Attorney General in its misdirected determination of the petitioner's PSG. Next, I would discuss social distinction. We believe that this case doesn't meet that definition of social distinction. Excuse me. In that the home society in Honduras does recognize this group as being distinct and identifiable. It has characteristics that are visible and recognizable by others in Honduras. In fact, the government of Honduras has itself recognized that witnesses to illicit activities of criminal groups like petitioner is distinct and socially visible in the Honduran society because the government's enacted ineffective witness protection program. I would next want to briefly discuss nexus. The board and the immigration judge conflated the issues of past persecution and nexus in this case. They didn't really discuss past persecution, they just jumped to nexus. And clearly in this case, petitioner suffered past persecution. He was kidnapped twice by members of the drug cartel, and he received threats that he would be killed if he did not join them. There's one central reason why the drug cartel was after him is because they wanted him to join them. They wanted him to sell drugs and cooperate with them. And he failed to do that. He refused to do that. And he even went as far as to go to the police to seek protection. Of course, the police failed to protect him.
Well, he was kidnapped or approached twice, I think. Is that right, by the cartel folks?
Yes.
Yeah, but if I'm remembering this correctly, he didn't go to the police until after those events happened.
Correct.
And the reason I ask that is the way your particular social group is worded. It's a Honduran male who reported to the police drug activity, but the police failed to take action. But he had not reported to the police at the time those events occurred.
Correct.
So they couldn't have sought him out for having reported police activity because he hadn't done it.
That's correct. So our focus would be on the future persecution, well-founded fear of future persecution, in that he's established past persecution, and that he's suffered his kidnappings twice, and he's received death threats, and that constitutes past persecution. So then the burden would shift to the government to show that he's that the conditions have changed in the country, that he would not have a well-founded fear of persecution. Because of the situation in Honduras where you have these drug cartels are throughout the whole country, and you have a lot of impunity by the government officials, the security officials, and a lot of corruption in the government. And it's even clear this specific facts here where the petitioner went to the police, sought help, sought protection. He was told, we can't help you, join up with the drug cartel or leave. I don't know that anyone would doubt that that's a responsible position for a security officer, for a police officer to take, to tell someone, oh, just join up with a criminal gang or leave. and which plays into the issue that the board said, well, the petitioner could relocate. Well, again, that burden is on the government to show that where we've established past persecution.
And in this case, the government didn't engage in the country report as to the cat claim, did it?
Correct, it did not.
Well, that's what you should be arguing, yeah, because we're on the cat claim now, right?
Moving in almost, yes.
You should be, because we pretty much got the
Yeah, that
protective
was-
group, right?
Yes. And here it's clear that the petitioner will suffer if he returns to Honduras by or with the consent of a public official. There's willful blindness here. I mean, I would argue it's even more than willful blindness if the police officer is telling them, join the drug cartel or don't. And yeah, the State Department reports, which this court has held, the Ganahasa case, that's the best evidence to demonstrate, country conditions and what's potentially likely to happen in the future. And the board totally disregarded that evidence. So we believe at the very least, with all the impunity there, the corruption, and that the police are even involved, according to State Department reports, with these criminal gangs, that the petitioner's life is he's more likely than not to be tortured if he returns to Honduras. That was pretty much what I had. I would just, unless there's further questions, I'll sit down and reserve time for a rebuttal.
Okay, thank you, Mr. Ritchie. Ms. Stroka?
Good morning, Your Honors. May it please the Court. My name is Jessica Strokas, and I represent the United States Attorney General. This Court should deny the petition for review because substantial evidence supports the agency's particular social group cognizability determination, the nexus determination, and the determination that it's not more likely than not that the petitioner would suffer future torture if returned to Honduras. Beginning with the particular social group, Honduran males who reported cartel activity to the police, but the police failed to take action. I believe it was Judge Diaz and Judge Agi that pointed out that in Morales, this court determined that an analogous particular social group consisting of Salvadoran women who are witnesses to gang activity and targeted because they filed a police report lacked both particularity and social distinction, the identical determinations that the agency had made in this case. The particular social group here lacks particularity. It lacks definable boundaries that are clearly defined, and it has traits that are amorphous, overbroad, diffuse, and subjective. The collection of traits here has no sharp boundary line, as the court said in Morales, and the medley of vague traits bled into those of the general Honduran population, undermining the very purpose of particularity, which is to avoid indeterminacy. The trait of having reported is itself vague, as I believe Judge Diaz pointed out, that what does having reported something mean? Does it mean that a true police report was actually taken? Does it mean that it was just said and nothing was taken? Does it mean that there has to be an investigation or any kind of further action taken by the authorities? What does that term mean? That is exactly what a amorphous, overbroad, diffuse, or subjective term is. As for social distinction, again, there is a lack of evidence here showing that this group, Honduran males who have reported cartel activity to the police, but the police failed to take action, is recognized by others in Honduran society as being a discrete group of people. Here, there really is a dearth of evidence in this case. And the evidence indicates, quite sadly, that gang violence does affect a large swath of the public. But the country conditions evidence here doesn't show that Honduran society as a whole considers this group, Honduran males who reported cartel activity to the police, but the police failed to take action, as being discrete from others in society. And the dearth of evidence certainly doesn't compel the conclusion that this group is socially distinct. The existence of the witness protection program, the single sentence in the country report about a witness protection program, also does not compel social distinction here, because the group itself isn't discussing individuals who have entered into a witness protection program with the authorities or who intend to testify as witnesses against a gang member. And that's what that sentence is about. It's about, sadly, gang members intimidating witnesses and using violence to prevent them from testifying against other gang members. And that's just not what this group here is. This group, again, is Honduran males who reported cartel activity to the police. It's not Honduran males who entered into a witness protection program and were failed to be protected by the police. So the record certainly doesn't compel the conclusion that this group is cognizable. But even if it did, there is no nexus in this case, and the record doesn't compel a nexus in this case. With respect to the past harm, I believe this court has already observed that the petitioner was not yet part of his group when he suffered past harm, when he was approached and kidnapped and threatened by gang members when they asked him essentially to sell drugs at his private university. And the petitioner testified as such that he was approached because he was a student at a private university and had an access card to those grounds, and the gang wanted him to sell drugs on their behalf. With respect to the fear of future harm, being potentially on account of being a member of this group, Honduran males who reported cartel activity to the police, but the police failed to take action, there's no evidence in the record that shows that there's anyone in Honduras that has any interest in harming the petitioner for that reason in the country conditions evidence or in the petitioner's testimony. In fact, he testified on pages 102, 104, and 107 of the record that the gang would harm him in the future because he refused to work for them, that the gang would want revenge because he refused to work for them, and that the gang wanted to harm him because he refused them. But this court has already held that refusing to join a gang or personal retaliation or retribution over purely personal matters, such as gang recruitment, are not cognizable bases for granting asylum. So while the petitioner may have a subjectively genuine fear of returning to Honduras, because asylum is not intended to cover the numerous personal altercations that invariably characterize social relationships and interactions, where he's failed to show the cognizability of his particular social group or a nexus between his feared future harm and his membership in his group. This court should deny the petition for review. Turning to CAT protection, substantial evidence also supports the denial of CAT protection, where his CAT claim is based on the same set of events, and the petitioner did not establish that he was more likely than not to be tortured by anyone in Honduras.
Well, he offered a statement, at least, that he had gone to the police in his hometown and they had told him, well, you either have to get along with the cartel or you leave the area. Well, he did leave the area, but I don't know that the BIA ever dealt with that particular statement in its opinion. I think the immigration judge noted that he'd consider it, but that would at least be some evidence that the government had declined to protect him.
Your Honor, the way I read the CAT determination, while the board does use the term acquiescence, the remainder of the opinion there really, to me, reads as a likelihood determination, that he didn't show.
I'm sorry, say that. I just didn't understand.
I'm sorry. To establish eligibility for CAT protection, the applicant must show that it's more likely than not that he would suffer future torture, harm rising to the level of future torture, and that action would be by or with the consent or acquiescence of the home government. And so here, the way that at least I read the board's decision is not that it's so much an acquiescence determination, but that the agency is saying that he's not satisfied that kind of first prong, that it's not more likely than not that he would suffer future torture from any source in Honduras. Although I will point you to, there's a sentence in the board's decision there that is, moreover, he was not threatened or approached after he left the area where he had been the object of recruitment efforts. And so the board did consider that he had relocated at some point after having suffered these recruitment efforts and reported to the police.
But the court didn't address the country report. They didn't address the country report. They only addressed it narrowly as to whether or not, in fact, he was a person who had actually was in a witness protection program, and therefore there was nothing that said report about that, him being a part of that, because he wasn't in there except for his one reference. But it didn't, that's a procedural problem, isn't it?
Your Honor.
But show me, first of all, before you answer the question, where did they engage as to the CAT claim in terms of the country report?
As to the CAT claim? So the CAT claim really talks more about, the CAT determination by the board really talks more about his personal individual circumstances, his particularized risk of future torture, which certainly could be informed by generalized country conditions.
Absolutely, we said it is. And you can't just ignore it. That's a procedural problem.
But the country conditions themselves alone, particularly where the individual has not shown in his particular circumstances and as opposed to the general evidence, that he's more likely than not to be.
But he is. Remember, we're not talking about protective group now. We're talking about the CAT, right?
Yes.
Here is very particular, and I don't know why it was not included as a group, but he's a student. They targeted him not just because he was a young male. That is true. They put that there. But it was because he had access to the university that was closed off to the cartel. It was his access. That was very particularized. That wasn't addressed at all in terms of the CAT claim. Or the country report of how pervasive the crime is and the danger. And you had to admit, kidnapping and being threatened with death is torture, right? It's persecution, correct? This court has established that. Will you agree with that?
I believe that this court has said that death threats can be past persecution, yes.
Yeah, right. So you agree with that, correct? He was kidnapped twice.
Yes, I believe
And he
that
was threatened with death, correct?
Yes, I believe this court has said that death threats can constitute
Yes,
past
and they
persecution.
didn't, and that's in the record, undisputed, correct?
Yes.
And his credibility has not been attacked here. Matter of fact, they said it was consistent. Is it correct?
Yes, Your Honor. I
Well-
will point out, though, that recently the Supreme Court in Ming Dai has distinguished between credibility and satisfying a burden of proof. If that credibility alone is not enough.
Well, you didn't even engage with his proof. His proof was a country report, and you didn't even engage with it. That's the problem. That's a procedural problem. Forget about in terms of winning on the merits. You have to engage with his record. You said, well, he did, but how did you? Where's the
Your Honor,
engagement with that?
I believe that perhaps we're talking past each other.
I don't think so, because you opened it up. That's why I let you lay out why the CAT claim was not prevailing, and then you admit that they didn't address the country report with the CAT claim.
No, Your Honor, they don't. The board does not explicitly address the country report.
That's the only way you can do it. Well, we have to read it.
However, I will say that for CAT, specifically when looking at particularized risk, this court has said that a country report alone, generalized evidence, is not enough.
But it's not alone. That's what I'm saying. Should he give up being a student? Is that the price of his safety? I no longer want to further because as he said, I want a new life. I want to have a decent, law-abiding life and be an educated person, and he had already picked his career. Would be the price of him being safe in the future?
Your
That's
Honor,
particularized to him, is it not?
perhaps if we were talking about asylum or withholding of removal,
No,
the
we're talking about a
protection
CAT
has
claim.
a very high burden. It is a very high burden, and it
It's
does
a
not
high
consider.
burden, but you have to at least give some rigor to that you looked at it. Don't you think that's very particularized that he's a student? He was chosen because he was a college student there.
Yes, Your Honor. And however, I would say that when we're talking about torture convention protection, there is an
I'm sorry,
expectation.
you're talking about some kind of protection. I didn't hear what you said.
CAT protection, torture
Okay,
convention
all right.
protection.
Right?
There is even an expectation that someone could relocate, that
The school is
that
gonna
they would
move
do
him?
what they need to do.
The school is gonna move for him?
No, that the individual, I assume that there's more than one university in Honduras.
Is the record shows that you even engage with that? That's the whole problem. You look at, that's what you say, we know he goes to college, but there are 5 or 6 other universities over here. Is that in the record?
Your Honor, I believe the point that I'm trying to make is that,
I understand your point, but is it in the record?
that we have one country report that the petitioner submitted in the record.
No, it's
I
a
think
record
it
that
talks about
you said you believe there's several colleges that are available. Is that in the record, the other choices?
No, I said I assume that there would be more than one
We
university.
can't take your
in
assumptions,
Honduras.
counsel, although not besmirching your honor, I'm sure you're honorably so, but that's what we have appellate court, we have to look at a record.
Yes, Your Honor, and I believe the record here shows that the petitioner did not provide any evidence other than his speculation that someone would want to torture him in the future.
Counsel, can I ask?
Go ahead, I'm finished.
So I think part of the problem here is understanding exactly what it is that we're reviewing when it comes to the CAT claim. So our case law indicates that unless the BIA adopts the immigration judge's opinion, we look at the BIA's opinion standing alone. And Judge Agee and the Chief had indicated to you some concerns that they have, and frankly I have as well, with respect to the BIA's opinion, that it doesn't seem to engage with the petitioner's evidence, the statement that he made about being told that he had to cooperate with the cartel or move somewhere else, and the country conditions report that the Chief talked about. On the other hand, if we are allowed to consider the immigration judge's opinion, if the BIA in fact adopted it, the BIA did engage with that evidence and said, well, you know, he did make that statement, it's credible, but I looked at the record evidence in this case and I find that the Honduran authorities are trying their level best to improve the law enforcement and police effectiveness. And sometimes they're ineffectual, but for the most part they are. And so I reject that claim on that basis. But we can only do that if in fact the BIA adopted the IJ's opinion. So what is your view on that?
So the board says that there's no clear error in the immigration judge's determination, that the record does not indicate that it's more likely than not that he will face future torture in Honduras. So to the extent that the board does find no clear error, the board is looking at the immigration judge's decision there. And so this court would be empowered to consider both determinations. But again, looking at the board's determination, or excuse me, the board's decision here, the board really does focus on this likelihood of future torture element.
But it does so in the abstract. It doesn't really engage with his evidence of the particular statement that he made that's particular to him, and the IJ did. So I get your point. If we, at least if I don't know about my colleagues, agree with you that that the BIA adopted the IJ's opinion below, then I think you're on much firmer ground as to the completeness of the analysis of the CAT claim.
Yes, Your Honor, but I do also want to point out that the board does engage in some analysis in the CAT claim here as well. They say that there's no past physical harm that he endured, and that he was not threatened or approached after he had left the area, where he remained from between June 2014 and the end of September 2014, and that.
Well, there's no doubt that's powerful evidence and a powerful argument. But I guess the question is the board allowed to go directly to that if it doesn't adopt the IJ's opinion that dealt with the other evidence, the country report, its finding of credibility as to what the petitioner testified to and that sort of thing? I guess it's sort of the same question as Judge Diaz asked. You're not incorrect to point out what the BIA did consider. I guess the bottom line question is that enough when it omits the other items?
Your Honor, I will again point out to the first sentence in the CAT determination that it is reviewing the immigration judge's decision, that there's no clear error here. And so I believe that, that in essence, what the board has done is adopted the immigration judge's decision by finding no clear error there and then adding further explanation as to why, and highlighting certain parts of the evidence here. For
Well, under that
example,
standard, then you'll say that every time they review the immigration judge findings, that that's an adoption. That's not the case.
certainly not, Your Honor. That,
You
that
said
would not
because they
be,
reviewed it, they didn't adopt it.
that would not be what I
Can you
would.
show me where they adopted, or that's an assumption?
Your Honor, on page 4 of the board's decision, the very first sentence, with respect to the respondent's application for CAT protection, there's no clear error in the immigration judge's determination. And then it goes on to discuss certain parts of the evidence, and the last sentence is, we therefore affirm the immigration judge's decision denying the application.
There's no clear error.
No clear error and affirmance.
And you're saying that's adopting, that's adopting?
Your Honor,
It tried to buttress his own opinion in the CAT claim by saying what you said, that in terms of, well, he moved for a month, grandparent, and that was their decision, right? That was their decision. It wasn't the fact that they, carte blanche, said, oh, we don't find an error. They weren't adopting it.
Your Honor, they say both that they've find no error in the immigration judge's decision and that they affirmed the decision. In my experience, and certainly you don't have to take my experience, but in my experience, when the board is affirming a decision, they're essentially they're looking at that decision and then they're
Affirming decision is the decision not to grant asylum, withholding of removal, and a CAT claim. That's affirming the decision.
and finding.
Adopting the findings is different than they review and say, we affirm the decision. The decision was to deny the claims. A relief.
Your Honor, I believe that would be a
You think that's
fairly
enough?
narrow reading of the board's standard of review.
I don't think it's narrow at all, but these are very important cases. I mean, it's literally life and death. And the whole idea is that for review in court, we have to have something to look at, whether or not the BIA is there to do that kind of, and this was a single judge, wasn't it?
I believe so, yes.
Right, so
The board
even less,
frequently employs
even
single
less
judges.
deference should be given to it. Skidmore at best, certainly not Chevron deference to that.
Your Honor, the board routinely
You agree with that,
employs-
don't you?
The board routinely employs single judge panels.
Well, they may routinely do so. We also routinely look at the difference, the level of, in terms of deference we give to it too.
Your Honor, I see that I'm over my time.
That's fine, you can keep on, I'm asking the question, but you can.
Sure. So,
But
as
you agree
I
with that
understand,
the
Your Honor,
deference is lower, even though you may do it often, it's sort of a quick review with one, but there
Well,
is a difference.
Your Honor, we're not talking Chevron or Skidmore here, we're talking substantial evidence.
Okay.
And under the substantial evidence standard, this court would have to find that there's overwhelming evidence compelling the conclusion that the agency got it wrong here.
Pretty much so. If it seems to me, it's also a procedural problem too. That's the problem.
Well, Your Honor-
That's the finding aspect of it, but it's another procedural problem.
If the court narrows in on his individual particularized risk, I believe that it would have to find that there's something in the country report that was not discussed by the board or the immigration judge that would compel the conclusion that he has a particularized risk of torture.
The
board's
only thing
decision-
discussed in the country report was in reference to whether or not, in fact, about the witness protection program in terms of that he did not put himself in the class. But it did not talk about in terms of how did that affect his being able to relocate, the likelihood that he would still face these people, which the cartel is nationwide and all those things. It didn't say it's nationwide, but he could. It's a threat to him to kidnappings but under his circumstance, it's not likely because. That's what we look for, and it's not there.
Your Honor, I think the board engaged in that analysis. I mean, the board says the respondent fears that the cartel members whose efforts he declined would locate him elsewhere in Honduras and torture him, or that other unrelated criminals would take notice of him and torture him for their own reasons. And the board found that on this record to be speculative.
It's speculative. You've already been kidnapped twice.
Your Honor,
I mean, let's think about the human side of this case, man. Attorney General, you represent the Attorney General. I mean, in terms of the policy that you're saying that most people aren't kidnapped, thank God, ever in their life. But twice kidnapped and told, I'm going to kill you if you don't capitulate to our demands.
and then he
And what do you
moved
call
in-
that? You said that's what, for some reason, we don't think it's likely it's going to happen again. Why not? What in the record says, the explanation of why not? Why wouldn't a person who they told you, we're coming back a third time, they told him that specifically, and the third time, that'll be your last time, we're going to kill you. Isn't that the record undisputed?
I believe,
Is
I believe
is
what
that
the-
in the record undisputed? That
What the
they
test-
said, we're going to come back a threat time. See, and this record is pretty replete with saying, it wasn't like 1, 2, well, we don't care if we see you again. No, it was a kidnap, threat, and said, we're coming back the third time, and if you don't do what we say, we're going to kill you. Now, you tell me where in the record it says that somehow that's lessened on his particularized reason in this record on a cat claim.
Your Honor, I believe he was told that if he didn't join the first time that they would kill him, and they came back the second time and they did not kill him. And then the third time, he left and lived elsewhere without being approached by
Is that
gang
different what I
members.
just said? I said they told him the second time they would be coming back a third time. I didn't say they came back a third time because he left. He came to the United States, a place where he thought he could be safe and
You're-
live in some kind of, right, is correct?
Somewhat, Your Honor.
What part did I get wrong,
In
counsel?
June 2014, he moved an hour away to live with his grandmother, and he did not leave there until September 27th, 2014. During that time he was there, he was never approached by gangs, harassed by gangs, threatened by gangs, harmed by gangs in any kind of way. And then I also want to back up to the first time that he was approached or kidnapped by gang members. He was threatened with death, I believe, that if he didn't sell drugs for them on the university campus, that they were going to kill him. And then they didn't. They did kidnap him again
Was
or
he a
approach him
student?
again.
Was he a student when he left the hour away?
I believe
Is it in the record?
I
Number
believe
two.
in his testimony that he was, I'm trying to remember, he was a student at the university, which is why he was approached in April. He was approached a second time in June. It's unclear in the record if he was still a student at that point. And then it's unclear if he had left the university before he came to, after he left the town he was in to move to a different town in Honduras, to then come to the United States. It's not clear if he was still involved with the university at that point. The testimony really focused on these kind of 3 points in time. April, he's approached, he's threatened. June, he's approached, he's threatened. June, he leaves, he makes a police report, or he attempts to make a police report, but he's told by the authorities that because he has no proof or no witnesses, they cannot make a report that anything happened.
And what else did they tell him?
And they also told him that that he should either kind of get along with the gang or leave.
No, he didn't say.
And he
Counsel,
left.
no, he didn't say no. The police told him, leave or join the cartel.
Yes, Your Honor.
And you could call that a police willing and able to help him when they tell someone join the cartel is your option?
So, Your Honor, for CAT, we're looking at a different kind of standard. It's similar to able unwilling, but it's the government acquiescing, or are they showing their
Is that
consent?
not acquiescing on
But also,
steroids? You can't believe that. That's like a police officer. You got to put yourself in the human side of it. Police tell you go to the police officer. You know, somebody just kidnapped me and threatened me. Well, you got any proof? Well, you don't have proof? I suggest that you leave or join the people who want to kill you, who are involved in illegal activity. You consider that to be the police officers, that there's some real hope of them. That's kind of acquiescence, isn't it?
Your Honor, I can't speak to acquiescence. I believe it would be a Chenery violation because the board's decision here truly reads as a likelihood determination. They don't engage in an analysis of the authorities or the public officials' likelihood to acquiesce or not. They truly are looking at this individual's particularized risk of future torture. So I apologize.
It's not a country report. They told him that.
Yes, Your Honor. What I was saying was that when looking at CAT, I do not see a government acquiescence determination in the board's decision. I see a particularized risk, a likelihood determination. And so I feel as if my hands are tied to speaking about acquiescence because
But
the
earlier you
agency's
said that
not
the
spoken
board had
for.
adopted the IJ's determination, and the IJ made a determination as to acquiescence, didn't he?
Again, I believe that the IJ uses the term acquiescence, as does the board, in kind of a setup sentence, but I don't see a analysis of the acquiescence prong for CAT protection. So what I see in the agency's determinations here is a focus on this individual's particularized risk of future torture. They're looking at what has happened to him and what he has said, and what evidence he has presented or failed to present.
And found that evidence credible,
Evidence that they found credible but not compelling and not legally sufficient.
but not explanation of why it wasn't uncompelling, because they didn't engage in it. They did not engage in it. That's a procedural problem. No matter what, at the very least, the case should be remanded for that to be done.
Your Honor, I believe that this court would really have to say that there's compelling evidence in the country report that the agency did not consider, notwithstanding the immigration judge's statements that all of the evidence was considered. And that there was such compelling evidence in that country report that it's more likely than not that he would suffer future torture based on this generalized evidence.
I don't think we have to do it at all. I think what I would say is that there's no compelling. We have to be showing the record that it was engaged in, and we can determine that it was considered. That's the procedural aspect of it. We don't have to say, fine, it was compelling or not in that sense. The question is whether or not it was engaged in. And our case law says that. That's a procedural error. In the cases we've sent back many times in terms of in that situation where they didn't even engage in the evidence. We didn't have to find, it's compelling. No, it is absent. The engagement is absent here.
And again, Your Honor, I have to point to the immigration judge's statement that all of the evidence was considered and that the board says that they reviewed the immigration judge's decision and found no clear error in it. And they affirmed that decision. And so I guess I would say to the court that the court would need to find, in order to send this case back for a redo of the CAT determination, the court would need to find that there is no engagement, that the immigration judge's statements and the board's review of it was flawed in some way. The immigration judge's statements are insufficient.
And were not adopted by the BIA, and the BIA didn't address it. That's not rocket science. I think it's due process.
And that Your Honor, the petitioner in this case did not raise a due process issue, and
It's always a
this-
due process issue in terms of when it comes to us. We have to look at it. You're asking this court to look at what happened below, and we have to address whether or not that was, and that's in our jurisprudence, in the Fourth Circuit, in many circuits.
Your Honor, I've not seen a court before address an issue that was not raised by one of the parties.
The fact that he made a CAT claim does put it in question.
Certainly, but this court reviews the denial of a CAT claim for substantial evidence. That's the standard of
If in fact they're
review.
engaged in the evidence that was presented in the record. When they don't, that's a procedural problem.
Certainly, Your Honor, but again, I'll point you to the immigration judge's decision where it says that all of the evidence of record was considered whether or not it is specifically mentioned. And in the board's decision, that they reviewed the immigration judge's decision, they found no clear error and they affirmed it. So perhaps we're just in disagreement on this issue.
What if and I hate to beat a dead horse here, but the BIA opinion had stopped at that first sentence in the final paragraph where it indicates, as you said, that the record does not indicate that it's more likely than not. It's relying on the immigration judge's determination. Full stop. It says nothing more. would you consider that to be an adoption of the IJ's opinion?
If the board says there's no clear, if it's just that single sentence?
Yes.
Well, the board cites this court's decision in Turkson as well as
Yes.
its own decision in
Well, you
matter
can
of
include
DCO.
those sites, but then skip the rest of the analysis. I guess part of the concern is they went on to engage in an analysis which suggests that perhaps they weren't satisfied with the immigration judge's decision, i.e. they didn't adopt it and wanted to go their own way. So that's what I'm asking. Is that first sentence by itself, I know you've said you think is enough to suggest that they adopted it, but if it had been there alone, would that be-
Certainly, the board there is saying there's no clear error in this decision. The board necessarily must review the immigration judge's entire decision in that aspect.
Frankly, I've never understood why we make these distinctions, but you think when it comes up to us, we'd review the entire record of all the decision makers, but our case law does indicate that the BIA, if it doesn't adopt the IJ's decision and goes its own way, then it's stuck with whatever decision it decides to make.
If I may make a suggestion there, and it has come up in this case, in fact, that the board here, when it's highlighting certain aspects of the immigration judge's decision, and frequently parties may want a decision made on a subject that is not part of the agency's decision. So while, for example, an immigration judge may find no past persecution or harm rising to the level of past persecution, the board, in this case, skipped a finding of harm rising to the level and went instead to the nexus prong, went instead to the cognizability of the social group. And so this court's scope of review is being narrowed by what the board is looking at. And here we have the board saying, we are looking at the immigration judge's decision. We find no clear error in it.
In its entirety.
That the board doesn't specifically say that
I'm not questioning you, I'm just suggesting
that it
Okay.
has narrowed it in any kind
All
of
right.
way. And again, looking at the immigration judge's decision itself, while both the board and the immigration judge have that kind of topic sentence that's very common that the agency uses, saying it's not more likely than not that you'll be tortured by or with the acquiescence of the government, both agency decisions narrow in on this particularized risk, more likely than not element of the CAT decision. Again, in the immigration judge's decision, I simply don't see an analysis of acquiescence. And so we have the board highlighting certain pieces of evidence, highlighting certain parts of the immigration judge's decision, while saying we've looked at the immigration judge's decision, there's no clear error in it, and we're going to affirm it. Another common way that the board will stylize something is adopting and affirming a decision. I apologize, I know I'm quite far over, and unless there are further questions, I probably should defer to my.
Thank you, Ms.
Thank you very
Storkus.
much.
Do you have anything further, Mr. Ritchie?
Just 1 or 2 minutes. I know it's been a long morning for your honors. If I may, our position is that nowhere in the board's decision does it state that it adopts the IJ's decision relating to CAT. So we would disagree with the government's position with all due respect on that. And we would I just want to clarify some facts. Petitioner, yes, he was a student going to school when he was kidnapped the first time. It was in April. Then in May, he received a phone call from the drug cartel saying, hey, you decide to join us? Are you going to join us? He declined. He said, no, I'm a student. I want to get an education. I want to do what's right. Then the next month, that's when they come kidnap him again and take him to the leader. And that's when he received the death threat from the leader. At the second kidnapping, the leader said, look, you've had a couple of times opportunities to join us. What's your position? No, I'm not going to join. He said, okay, you don't join us, you're dead. Next time we see you. And, the board, nowhere in that one paragraph where it discusses CAT does it discuss the most important evidence in the record, which is the State Department report. So we believe definitely that the case should be remanded, if not reversed, Your Honor. Thank you. Unless there's any other questions, I'll go ahead and sit.
Thank you, Mr. Ritchie and Mr. Dorcas, for your arguments, and we appreciate it, and wish you well. Thank you for helping us on this case. We'll proceed to our last case for the morning. Yes, whenever you're ready.
Thank you, Your Honor. May it please the court, my name is John Nepper, and I represent appellants who are state officials who oversee the North Carolina State Health Plan and have been sued in their official capacity. The state health plan is an employer-funded health insurance plan that sets premiums, and it uses those premiums and other state money to pay for health care for teachers and for state employees in North Carolina. Insurance is a trade-off. Broader risk coverage means more money. More money means higher premiums and higher contributions by the employer. Less generous insurance costs less. 50 years ago in Godoldig versus Aiello, the Supreme Court held that the Equal Protection Clause does not require government insurance plans to cover more or different actuarial risks than private plans, which are not subject to the 14th Amendment. Godoldig, which was just reaffirmed last year in Dobbs, held that questions about what are the coverage limits or what are the coverage exclusions are subject to rational basis review. With state-sponsored insurance plans, the Equal Protection Clause looks at whether there's a facial classification in the risks insured against, not in the ultimate payout to the employee. Godoldig holds that a plan does not violate the Equal Protection Clause so long as there is no risk from which men are protected and women are not, and when there is no risk from which women are protected and men are not. Every beneficiary in the North Carolina State Health Plan receives coverage for the same health risks. This is no less true for plaintiffs who are transgender or the parents of transgender individuals who receive the same coverage for the same health risks as every other plan participant. Importantly, and this is the holding of Godoldig, rational basis review applies even when the coverage exclusion, in Godoldig it was pregnancy, disproportionately or even only affects individuals within a protected class. The court said that circumstances addressed, those kinds of circumstances are addressed by looking for a discriminatory motive. And this circuit's case law is clear that motive is a question for trial, not summary judgment. The court below concluded without a trial on summary judgment that the plan's coverage exclusion for treatment or studies leading to or in connection with sex changes or modifications in related care is a facial classification on the basis of sex or transgender identity, and then it imposed heightened scrutiny.
You didn't move for summary judgment.
No, Your Honor, you did
Okay.
not. The plan's perspective is that the plaintiffs have the right to make these motive claims at trial, and we didn't think that we think that's not a frivolous argument by that. We think it's wrong, but we certainly wouldn't purport to say that they can't. The record, factually, the record on summary judgment is that the plan and its contractor never look at biological sex or gender identity at any time
when making a coverage decision on the benefits that the plaintiffs are concerned about. The exclusion, more importantly, the exclusion does not classify individuals on the basis of their biological sex. The phrase sex change, albeit let's acknowledge that that's language more appropriate to the 1990s when the exclusion was adopted than to sort of our modern day understanding. It describes medical procedures for the treatment of the psychiatric illness of gender dysphoria. The plan doesn't need to know an individual's sex or gender identity because no one gets gender-affirming care or medical procedures that involve sex changes or modifications. Further, the exclusion does not classify individuals on the basis of their transgender identity or gender identity. It does not reference whether someone is transgender or not. The testimony in the record is that the plan and Blue Cross Blue Shield, the current third-party administrator for the plan, don't know whether any beneficiary is transgender. It's simply gender identity is not something the plan tracks. The plan is an insurance plan. This is not some sort of moral activity. I mean, no one expects their insurance company to care about decisions like that in terms of some sort of judgment, and the plan just simply not interested in that.
What are you interested in then, in terms of deciding that you won't deal with gender dysphoria? Well, you said you're not interested in that. What are you interested in to make the determination that categorically you give no medical coverage for dealing with the anxieties and those things that may follow from it? What is it?
So I'll come back to sort of some of the factual.
No,
it's not accurate that we don't cover anything.
No, I'm using your words. So we don't care about this. What do you care about to decide that you? Wait a minute. What do you care about that's so important that you decide that categorically someone who has gender dysphoria should get no medical coverage for treatment, whatever? What is it?
The plan is broke. The plan, we're seeing healthcare costs rise at 7% per year or more. The appropriations from the General Assembly of North Carolina.
And that's for people who want an aspirin too. That's for everybody, right? If you're going to use the economic, are you now going to the economic model? Then why pick on then transgender dysphoria then to settle or balance your books?
Your Honor, that's not been the approach. The approach of the state
you
health
brought
plan.
it up and you said that everybody knows. I'm just trying to find the zero in what you said.
Yeah.
You were saying we don't care about this and that, and then I'm saying, what do you care about? Then you went to economics. I'm still trying to get to what is it that makes this treatment so important that you categorically say we won't even treat it, won't even look at it, nothing. Tell me that.
Your Honor, there are two intertwined issues here. One is the state health plan has.
You answering my question?
I'm answering your question right now.
Okay, go ahead.
One, the state health plan applies this approach to all sorts of diagnoses. You're talking as though this is the plaintiffs have been singled out and that the plan is making other decisions that are inconsistent with that, but they're broadening their coverage. The plan is regularly receiving requests, expand the coverage because I have this medically necessary need. I have this medically necessary need. And what the record says and what the plan administrators have said is that for small benefits, they are saying no to everything because they have reoriented their plan's overall approach. They are
Counsel,
focused
you
on.
just answered the question. You said on those other situations, you're looking at medical necessity to make those decisions. But here, you're not doing that, are you?
Your Honor, it's just the opposite. We're saying.
Did I miss
We're saying that, yeah, my point was simply that regardless of medical necessity, in other words, we're not arguing,
So you mean tell me the other people who need it and you are unequivocally convinced they need it, you decide you're not going to get it?
I'll give you, the state does not cover hearing aids after age 18, period. There's no question, I think anyone would question, there's certainly no question in the record, whether that is a medically necessary service. And people come to the plan and say, hey, I need coverage for hearing aids. This affects my life. And the plan's approach is, no,
You don't do it based on sex, do you?
we don't, just as this, we don't make any of these decisions based on sex.
Well, let me give you an example that the district court honed in on and explained to me why this analysis is faulty. So Judge Biggs, at page 42 of her opinion, gave this example. The plan apparently covers puberty suppressing medication if medically necessary. Do you agree that that's right?
No. The plan covers puberty suppressing medication for the diagnosis of precocious puberty.
So if medically necessary, in that instance, you will cover that, right?
For that
Okay.
diagnosis, yes.
So then Judge Biggs says, but a transgender boy who will not receive coverage for that medication, even if medically necessary, because in the language of the plan, it would change or modify his physiology in a way that doesn't match his female biological sex. So in one instance, you're providing the coverage because it's medically necessary. In another instance, Judge Biggs says you're not, precisely because of the sexual component of the diagnosis. What's wrong with that?
What's wrong with that is that you are omitting what makes, you're changing the underlying comparison. A transgender boy with central precocious puberty will receive hormone-suppressing drugs. That's, the plan is not going to say to that person, you can't have it. Just as a transgender man or transgender woman who has breast cancer can have a mastectomy. The plan doesn't say no.
That's fair enough, but then the question is, why is that transgender boy not being given the medication in other instances? And Judge Biggs found that it's facially because the plan is discriminating on the basis of that boy's sex.
I think there's sort of two elisions there. One, the plan is discriminating on the basis of diagnosis. The plan doesn't know the sex, doesn't ask the sex. I mean, it's worth noting that all biological sexes, for example, are able to receive coverage of puberty suppressing drugs. And that's in the record when you look at the authorization criteria. It applies equally to biological males and biological females. The question is, are they receiving that for the treatment of that illness, or are they receiving it for treatment of another illness? And Geduldig actually answers this question, because Geduldig says that we don't look at sort of the underlying outcome, like whether or not you got the payout. Geduldig doesn't disagree with the fact, with the plaintiff's assertion that pregnancy is a disabling condition. The court didn't say, well, the pregnancy is a disabling condition in a different way, or the plan is entitled to cover it because there's some sort of difference. It said simply, yeah, pregnancy is a disabling condition. There are other disabling conditions. The court, the state insurance program is allowed to make that decision so long as there is a rational basis for its decision, and it's not it's not being made because of the individual's membership in a protected class. And I think that's sort of the key point.
So can you tell me how our decision in Grimm fits in all of this? Are you indicating basically to the extent that Grimm is inconsistent with Geduldig, we should ignore it? Or do you think it's just not relevant to this case?
I think, Your Honor, you don't have to do anything with Grimm to rule in favor of the state health plan here. And that's because Grimm is a facial classification. I mean, Grimm is saying to people, you have go to this bathroom, and we're making the decision about those questions. In this case, again, the state health plan provides equal coverage for all health risks. There are just some health risks it doesn't cover. And I think, some of the questions that Judge Gregory asked, I think are absolutely the kinds of questions that the plan will be responsible for defending on remand. In other words, these questions of motive are absolutely things for which the plan will have to say, no, we're doing this for broad-based reasons in spite of membership in the protected class, not because of membership in a protected class. But for the analytical purposes here, it's simply not a facial classification. It's a proxy, and proxies under Bray and elsewhere are analyzed for motive, not analyzed as a separate class.
But the problem is it's found as facially infirm, though. It's facially infirm. That's what the ruling was. And so the motive is not necessarily the question, is it? It's facially infirm. That was the ruling, the basis of the summary judgment, correct?
And yes, we disagree with that.
I know you, that's why we're here. We're here. But the point is, we don't have to deal with motive in that, in terms of you're making a difference in terms of the district court found based on sex. Because transgender dysphoria has to deal with a person's sex, doesn't it?
Well, and this is, and pregnancy has to do with sex. I mean, in other words, that's, which was Geduldig. The important thing for Geduldig is, and this is in the record, whether someone's transgender and whether someone has gender dysphoria, the illness, are separate things. And everybody agrees, and the plan agrees, that someone who is transgender is not mentally ill. Does not, that fact alone does not determine whether you have the mental illness of gender dysphoria. It's a subset of people who have that mental illness of gender dysphoria. In Geduldig, the court said, we've got two buckets. We've got pregnant women and non-pregnant women and men. And that's not a classification. In this case, we have individuals suffering from gender dysphoria, and we have individuals who are not suffering from gender dysphoria, who are both transgender and not transgender. It's the same parallel reasoning as a Geduldig, and the court says that's not a facial classification. And I think, and I apologize, I've gone a couple seconds over. I just wanted to finish my thought. I apologize. Part of the, never mind. I'll sit and save the rest for about, unless you have any other questions.
All right.
May it please the court.
Counsel, Mr. Rep. All right.
Tara Borelli with Lambda Legal on behalf of the plaintiffs' appellees.
Yes.
I'd like to address at least two issues today, the two main issues addressed by my colleague, why this is a facial equal protection violation, and second, why Geduldig versus Aiello does not apply here for multiple reasons. Let me begin with that equal protection issue, however. To quote the exclusion, it precludes care for, quote,
Can you
sex.
move that
But
mic
there-
closer to you?
Oh, yes, I apologize.
But the issues you've just described have got to be related, because that was the argument in any number of these cases, Geduldig, Gilbert, Bray, even in Dobbs, that I don't see how you can really separate them.
Yes, so there's several reasons Geduldig doesn't apply. And the first is that facial explicit discrimination that the district court found. Sex changes or modifications. That's the text of the exclusion. It's plain as day. It says precisely what the plan prohibits. And that distinguishes Geduldig. First, Geduldig
Because they
doesn't...
use pregnancy is the language there, as opposed to saying women who are about to give birth.
Yes, so the court examined
I mean,
pregnancy.
that's the reason.
So yes, so let me be clear. The Supreme Court described what it was doing in Geduldig, and we actually see this in a second decision in Bray versus Alexandria, where Justice Scalia, writing for the majority, said in footnote 3, in Geduldig, we examined a, quote, facially neutral benefit plan. The court looked into Geduldig to find whether pregnancy could be considered to be sex discrimination, and the court found that's just not close enough to sex discrimination. It's objectively identifiable. We can describe it without referencing sex. It's not the same as sex discrimination. The second reason that Geduldig doesn't apply, the next critical distinction, is that there was no differential treatment in Geduldig because nobody was receiving disability benefits for pregnancy. And in fact, my colleague just quoted that language. There's no risk from which men are protected. There was no risk from which men are protected and women are not, and vice versa. Here, if we were to have Geduldig applied to the plan here, what that would look like is a prohibition that says no one receives coverage for a hysterectomy. But that's not what this plan does. This plan instead says...
Yeah, but that's a different treatment. That's a different diagnosis.
Sure. What I mean to say, Your Honor, that...
Well, but the point is that, this is what struck me about this case. If this were a statutory ban, I would follow the district court's opinion and your arguments, better, but the Supreme Court has a long, long string of cases that deal with employee welfare benefits. Whether it starts with Godeldig, Gilbert, Bray, and then even just recently confirmed in Dobbs, they're on a different track, which doesn't mean there can't be a facial challenge made to it. But I think it's really an apples and oranges comparison to try to differentiate when there are diagnoses in welfare benefit plans. And that's how these insurance plans work. And it doesn't matter whether it's gender dysphoria or LASIK versus cataract surgery. It's based on a diagnosis, and it applies to everybody.
A couple of things. First of all, this exclusion doesn't even reference a diagnosis. It lays especially bare and plain what its purpose is, which is it disapproves of what it sees as a sex change. My colleague correctly noted that that's now considered outmoded language. But that's the exclusion that was adopted. If we view you as, quote, changing your sex, that's improper behavior, and this is categorically excluding you
Well,
when the
no,
same
it doesn't say
procedures.
that. It just says we're an insurance plan, and this is something we're not going to cover.
Sex change or modification, that is the exclusion in the health plan. That's in the plan booklet. And my colleague mentions that the contractors who implement this care, they don't care about sex or transgender status. They're bound by that exclusion. And those are the explicit terms of the exclusion itself written into the handbook plan.
Are you suggesting that the plan could have achieved this result simply by changing the label?
Not at all. I think the targeted discrimination based on sex and transgender status is plain. And my colleague has offered in briefing a few different ways of attempting to rewrite the exclusion.
But if in Godeldig, it couldn't have been rewritten to say women who are about to give birth, it doesn't make sense to me that you couldn't say with the same line of reasoning in this case that you could have rewritten that exclusion to say there's no coverage for breast or genitalia treatment without a specific diagnosis of physical injury or some other underlying disease.
I understand that they have offered that in their briefing. First of all, they have
Well,
to...
but how is that any different from if you'd reworded the exclusion in Godeldig?
Well, first of all, that exclusion, that attempt to rewrite it, what they're asking this court to do is to pick up its judicial pen and rescue this exclusion by rewriting it, because the one they've adopted and the one that they actually have to defend is so indefensible. It so plainly and clearly discriminates based on sex and transgender status. And Grimm is the applicable authority. It says that heightened scrutiny applies. And so I want to make sure that I've been clear on that point. That rewriting wouldn't even succeed. There are definitions of medical necessity. The record has them. The North Carolina has adopted a statute identifying the criteria for medical necessity. And the undisputed, all the admissible, undisputed evidence in the record is that gender dysphoria meets that definition. So that cannot be a basis to distinguish here. And each of the different
Well, but your
rewritings-
colleague on the other side makes the point that they routinely exclude treatments and procedures that might well be medically necessary simply because of cost.
They can draw neutral lines. This one is based on sex and transgender status. Other neutral lines can be drawn. That's what insurers do as a matter of course. But when they do so based on sex and transgender status, they have to justify it under heightened scrutiny. Let me turn back to a point I was making a moment ago, if I may, about a second reason that Godeldig should be understood not to apply here. The Godeldig court was very focused on the fact that there was no differential treatment. Everyone was treated the same there because nobody was receiving disability benefits for pregnancy. This couldn't be more different. This plan says many people receive coverage for hysterectomies or hormone therapy or vaginoplasty. The difference is if we see you as changing your sex, changing or modifying your sex, the care is off limits for you. We're going to draw that sex-based line. And so the differential treatment here is undisputed.
Yeah, but all those items you just described, they are available to everybody.
So they're available without discrimination for other diagnoses. But a very clear principle of equal protection is the fact that this plan is not discriminating in every conceivable respect against transgender people does not excuse the discrimination that this exclusion heaps upon transgender people. And that leads me to another point that my colleague
But it
made.
seems like that then goes to the general basis for the facial argument, that you may well be able to show that there is a disproportionate impact, but these cases are legion, even in some of the lists that's the descendants of Godaldig, that's not sufficient, that you've got to show pretext in that context. And I think that's all the opposing side has said is we need a trial on motive.
So intent is another way that one can show that a plan discriminates, but so is facial discrimination. Godaldig does not foreclose facial discrimination. Godaldig simply didn't involve facial discrimination. And that's a reason, a core reason that it doesn't apply here. That's what the district court found, and we believe the district court was correct. I want to make sure I'm answering the court's question, though. I'm sorry, would you mind restating the question?
Well, I think we're sort of talking at cross purposes here. It's almost as if the district court assumes that because there's a term in an insurance plan that relates to sex in any way, that equates to facial discrimination. And I still don't understand how, if you take completely synonymous language in Godaldig, as instead of using pregnancy, women who are about to give birth, that's any different than what the language is in this plan. Because that has to be sex-based.
Your Honor, that's the view that lost in Godaldig. That view that it has to be sex-based, it is sex-based, that's the view that's found in the minority opinion, in the dissenting opinion. And the majority and subsequent decisions of the court were very clear. Again, Justice Scalia, footnote 3 of Bray versus Alexandria, we were reviewing a facially neutral benefit plan. The analysis has certainly been critiqued, but that's what the court viewed that it was doing. Here, the discrimination couldn't be more explicit. Sex changes or modifications. It's just right on the page, on the
You seem
face
to
of
be
the
suggesting that if the Godaldig case came up before the Supreme Court again, the result might be different, or?
I'm certainly not suggesting that it would be different or that it would need to be different for the district court to be correct here. I think the district court was simply correct that it doesn't apply. And let me turn to another reason that Godaldig doesn't apply here. So if we consider the transgender status discrimination claim that plaintiffs have made, the more analogous case law is Christian Legal Society and Williams versus Kincaid, not Godaldig. Christian Legal Society says that when status and conduct are closely correlated, the court declines to distinguish between them. So in that case, for example, the court found that discrimination against same-sex intimacy was the same as discrimination against gay people. And this court cited that authority, recognizing it as the more applicable authority, and said in Williams versus Kincaid, as a matter of constitutional avoidance, that if a law, in that case like the Americans with Disabilities Act, excluded gender dysphoria from its protection, the court would have, quote, little trouble concluding that it discriminates against transgender people. So that's an additional reason.
But again, here, these are cases that deal with statutory bars. And the Supreme Court has gone down this long road in employee welfare benefit plans that takes a different tact.
Your Honor, again, please do help me make sure that I'm responding. I don't think that there's any distinction in the law, and it certainly doesn't emanate from Godaldig, which didn't deal with health insurance. It was dealing, of course, with a disability benefits plan, that says that when a state acts
Yeah, but the underlying concept of all of those cases is you have this, it's just like in ERISA, the term employee benefit plan covers everything, disability insurance, health insurance, all of those things that don't deal with retirement or life insurance, that these are based on actuarial assumptions. And we treat these cases differently than we do other types of cases. Otherwise, all these cases may have been decided differently.
Your Honor, let me make sure that we agree that there's government action in this health plan. It's subject to review under the 14th Amendment. I want to make sure that that foundational principle is one on which we agree. The second one is there is no authority of which I can think of in which the Supreme Court has ever said that if the government is facially discriminating in a health plan, that somehow is off limits from challenge. And that's what this case is about, a facially discriminatory exclusion. Sex changes or modifications, we're taking that off the table. It doesn't matter how medically necessary it is. It doesn't matter that other people receive these procedures. And they've admitted that. That's in the record at JA 3791 through 92 and 3810 through 11. The same procedures that plaintiffs seek are the same procedures covered for cisgender people. And the bar is this explicitly sex and transgender status-based bar that says no coverage for sex changes or modifications. Nor is this merely a disproportionate impact. The aim of this is transgender people. And I think Williams versus Kincaid helps explain that. We understand this as dealing only with transgender people. The Board of Trustees itself, in the minutes of the meeting where they discussed whether to provide equal coverage as they did for 1 year and then voted to deny equal coverage every year after that, was only and specifically about transgender people. Sex changes are definitionally, very outmoded language, but it is definitionally what defines a transgender person in the medical care that they need to treat gender dysphoria. So it's not mere disproportionate impact. This is a singling out exclusion that on its face, and there's no other reading in which it can be understood as anything other than sex-based and transgender status-based discrimination. I also just want to address another thing that my colleague mentioned, which was the point about cost. One really important point is that the Equal Protection Clause makes sure that concerns like cost, which insurance plans rightly have to grapple with, they must be a shared burden. There is nothing in equal protection that would authorize a state health plan to balance its budget on the backs of a vulnerable minority group. In other words, the state health plan could also save money by paying its female staff half their wages. And that would save money, but the Equal Protection Clause doesn't allow that either. And so there's nothing about cost that allows the health plan here to justify saving money by doing it solely on the backs of this vulnerable minority group. Let me turn, if I might, then to the evidentiary rulings. The district court properly excluded portions of defendant's testimony under Rule 702, and that's what makes this record, I think, so compelling, is that the court very painstakingly looked at the expert testimony that was offered, performed the gatekeeping duty that she is required to do under the court's precedents, and carefully teased apart and analyzed very deliberately, step by step, which opinions from the experts were admissible and which were not. Because, of course, non-admissible testimony cannot create a genuine dispute of material fact. As the district court found the admissible portions of these opinions, even when viewed in the light most favorable to defendants, they simply don't show that the care at issue here is ineffective, which was another argument that they've attempted to raise, but couldn't support with any admissible testimony. The fact that they weren't able to produce any such reliable testimony is not surprising, because as every legitimate medical organization has said for years, this care is medically necessary, indeed it's critical. So the district court found the plaintiff's doctors, the experts, all the medical associations, defendants' own third-party plan administrators all agree that gender-affirming care is medically necessary. They produced no admissible testimony to the contrary. And without that evidence, there's nothing in this record that can support the discrimination that this exclusion heaps upon the transgender participants in the plan. If the court has no further questions, for all those reasons, we respectfully request that the court affirm. Thank you.
Thank you.
Thank you, Your Honor. First, I want to touch base on this point that there seems to be this statement repeatedly that this is a facial classification. But Bray actually makes clear that if you're going to talk about facial classification, you have to use the classes. Bray says, women seeking abortion is not a class. The class is women, men, or in the case of transgender or non-transgender, cisgender. Those are classes, and you're not allowed to append on additional qualifications in the definition of the class. You have to. That analysis is performed at the plaintiff's burden to show that they're similarly situated. And so, we don't disagree. We fundamentally disagree with the notion that this is a facial classification. Second, I want to talk briefly about Kincaid because it doesn't apply for two reasons. The first is that if you read Kincaid's logic, it is exactly what Geduldig says is not the rule. I mean, Kincaid says, I want to make sure I get it right here, that gender dysphoria is very closely connected to transgender identity. So we have little trouble concluding that a law excluding gender identity disorder and gender dysphoria would discriminate against transgender people as a class. Well, in Geduldig, pregnancy is very closely connected to being a woman. And Geduldig says that's not the analysis. The analysis is, are there women on both sides of a ledger? There are non-pregnant women and men who don't want this benefit or don't need this benefit or get the actuarial reduction in cost by not having this benefit offered. And then there are pregnant women on the other side. The same is true here for gender dysphoria. Not all individuals who are transgender suffer from gender dysphoria or seek the treatments that are identified here by the plaintiffs. So there are, on the one hand, you have individuals with gender dysphoria who seek these treatments. And on the other side, and this is in the record repeatedly, it's unquestioned, there are transgender people and cisgender people who don't seek these medical treatments. And that is the logic of Geduldig, and Geduldig says that's rational basis review. I do want to talk.
You don't even get to necessity at all. You just categorically said gender dysphoria, period, cut off.
Yeah.
And if you're not at that level where you're making a determination. You said some have anxiety and dysphoria, and some don't. You're not at that level where you said, well, that's built in every plan, right? When someone makes a claim, excuse me, you're shaking your head, I haven't said anything yet.
Okay, I apologize.
Be careful. Every health plan, you submit for coverage, and then somebody in some place looks at codes and say, well, no, that wasn't necessary. That is. That's for every treatment. That's not the question. It's that you choose transgenders to say, we're not even get to the point of necessity. Categorically, we're not going to address your needs at all, period. And that's based on your identity of sex. It's not pregnancy that's temporary. This is their identity, who they are. It's not transitory. Women aren't pregnant all of their lives. So we're not talking, you're talking about you make this choice that we're going to cut transgender people from any health benefits at all in that regard before we determine whether or not they have any needs or not, because you're afraid it may lead to a sex change? Is that it?
No, Your Honor.
What are you afraid of then?
Your Honor,
What is the state so afraid of about that? You haven't answered that yet. What is it?
The state is extremely concerned about ensuring that it has control over the benefits that it offers because it is working to transition from a plan that covers everything a little bit to a plan that focuses on significant, broad population-based health risks. And in doing so...
Let me ask this question. Would you cover a circumcision?
Your Honor, that's not in the record. I can't say. I don't know.
Suppose you said, you think you could say we're not going to cover that? That wouldn't be...
Your Honor, the plan doesn't... whether something is medically necessary or not, there is no law that requires the plan to cover any particular health benefit.
Except when you target a protected class, and gender and sex is protected. And that's a heightened scrutiny when you do that.
Well, it's heightened scrutiny when we explicitly classify on the basis of sex.
I don't think it'd be more explicit when you say transgender. What do you need to say?
The exclusion doesn't say transgender.
What does it say?
The exclusion says treatment or studies leading to or in connection with sex changes or modifications in related care.
Well, then if your sex change, that's trans change gender, isn't it?
Your Honor, that's the proxy motive argument. And that's an argument that we would ask.
Proxy motive, that's facially what you said.
Your Honor, the record is clear that there are transgender people who have gender dysphoria and would seek these changes, seek this medical care, and would have physicians recommending it. And there are transgender people who don't have gender dysphoria and have no either desire or medical recommendation to receive this care. There are transgender people on both sides of the ledger. So it's not a facial classification of transgender people versus others.
Okay, so that's like saying, well, we have a facial discrimination against blacks, but it's okay because there's some black people who don't care about going to a restaurant at all. Others do. We don't look at that, whether or not their choices, whether or not there's some transgender persons who don't need services. You cut that off categorically. That is what we're addressing with, well, some people need, what is it, what difference does it make that some people may not seek medical attention or need medical services for, in connection with transgender, being a transgender person?
Geduldig says it matters because the actuarial benefits of not covering these services accrue to accrue to all individuals who don't seek those services.
Because there they weren't dealing with a facial infirmed provision in Geduldig, correct?
Your Honor, it is a similar case to this because
It's quite different. Am I correct that it wasn't dealing with a facial?
Your Honor, the point, the claim by the plaintiffs in Geduldig was you're discriminating on the basis of pregnancy. Only women can get pregnant. Therefore, you're discriminating against us facially on the basis of sex. And the court's conclusion was that that was not a facial distinction. Similarly, the plaintiff's claim here is you're discriminating against coverage of these specific procedures. Transgender people seek these services. You're discriminating against transgender individuals. That step is what needs to be resolved at the district court in a trial on motive.
So you say Grimm has no application in this case at all?
Your Honor, Grimm involved explicitly facial classifications. No one doubted in Grimm that there were, that you were being directed to sex-segregated benefits. And then the question was, who gets these sex-segregated benefits? In this case, there's no sex segregation of any of the health care benefits by the plan. If you qualify, you get it. And if you qualify, it's based on your diagnosis.
Right. The discrimination is based on sex. It's probably not as divisional as you said, but it is based on sex.
For facial classifications, Your Honor, it has to be distinctions between the class. Personnel Administrator versus Feeney is the case that comes back and says, well, if you're doing it because of sex, rather than in spite of sex, then that's still actionable discrimination. And that's the issue that we maintain would need to be resolved on.
And here they're targeted because of the difference in terms of their gender at birth versus their gender, who they are and their identity. Isn't it? That's the only way that they're in this category, where you decided not to give them. It's just amazing how we hear conflating, dealing with a person's needs, health needs, and as opposed to what somebody's making moral judgments, or what it is. What is that?
Your Honor, this is not, the plan has been clear, this is not about moral judgments. The plan's financial structure is that a family in North Carolina, many families work 1 week a month just to pay to enroll in this plan. The premiums for a family, and this is in the record in our briefs, are over $700 a month. If you want health insurance in the state of North Carolina and you are a state employee and you want to insure your family, that's how much money you have to come up with to insure your family.
Okay.
And the plan's perspective is that's too high.
All right. So do you have to pick on somebody then to do that?
The plan is picking on everybody. It is not.
Not in this provision, it's not. Not in this provision, it is not.
The plan.
Is that correct?
The plan is refusing to add new benefits whenever asked. This was a new benefit that was requested by plaintiffs, and the plan's answer was no. Others come before the plan and they ask for their benefits, and the plan says no. plan is,
When others come, it's not based on because of their sex.
that's,
That's the only way it becomes transgender. Gender, how one identifies with their sex. Their sex, at birth versus who they identify as their gender. I mean, you can't, they're inextricable.
except, I would know, Your Honor, that we treat illnesses at the plan. We don't treat people based on their gender. So in order to qualify for medical treatment at all,
I wish you'd say we don't discriminate against anybody based on how they consider their gender.
the plan doesn't. The plan doesn't even know.
Okay.
Anyway, I apologize, Your Honor, I went over.
No, I'm asking you a question. You don't have to
Yeah,
apologize.
I would say, there were a number of other issues that I think are more simple and more straightforward that were presented in our brief, and we rest on those.
All right. Thank you, both counsel. We appreciate your arguments and help on this case. And with that, we'll ask the clerk to adjourn the court for today at least.
This honorable court